Okay, we were back today in the Gibson-Martin case for presentation of the order of child support and the worksheets pursuant to the court's ruling. And Ms. Martin was to prepare the order of child support and the worksheets. Do you have those?
I have the worksheet, but I truly don't understand how to fill it out. I tried, but it's not even, I can't even get through the first page. I don't know what I'm doing.
Okay, well, there's a facilitator at the Clark County Courthouse a block away that helps people that are representing themselves in preparation of pleadings, so...
And they want money, and I just spent all my money buying documents because he filed another false report with DHS, and I've been busy taking care of those matters. I just got to this morning, and I truly don't know how to fill it out without help. I will make another run at it, Your Honor, but I am still consumed with trying to get safety and resolution.
You've had months to prepare this order, weeks rather, Ms. Martin, so you obviously are not setting it as a priority as to what you need to get done, in my opinion. You could have sought the assistance of the facilitator or someone else all these weeks to get this concluded. The issue I see, Mr. Gibson, is that I don't know what the new support transfer payment will be, and until these papers are entered, the temporary order that's in effect continues to be in effect. So whether the amount goes up or down, I cannot tell you. So you do have the option of preparing them yourself for presentation, because it appears Ms. Martin is taking the position she's not going to do it.
That's not accurate, Your Honor.
Ms. Martin has not done it for today's hearing. So I just need to advise you of that.
Thank you, Your Honor.
Again, I don't know what the new amount is until those papers are entered. The old amount that pursuant to the temporary orders remains in effect. Okay? So without any order of support, there's nothing further to discuss today.
Well, what about the $10,000 in back child support I was supposed to receive today?
At one of our previous hearings, Mr. Gibson volunteered to bring in $10,000 today towards his arrearage on his child support obligation. I roughly went over the previous judgments that were entered against him for support and what had not been paid in 2011, and my conclusion was that he owed over $10,000. At that hearing, he said he would bring the money in today as payment towards that arrearage. Are you prepared to do so?
Yes and no, and what I mean by that is in order to do that, we had to take out a refinance on the property that I own at 10104 Southeast Harold Street in Portland, Oregon. We have done that working through lawyer's title and the lender. Everything has been approved. When I mentioned on the stand that I needed 30 days, I felt that I was under, well, let's just call it what it was, pressure to be able to do what I thought I could do. Did not consider that we had Christmas and New Year's as holidays. Here is the preliminary title report for issuing the title insurance. All the paperwork is here. It's all in ongoing. I just need a little bit more time, and I've got the title report company. I've got the lender. It's all been approved. We have one person that needs to sign. What we have is a situation where one of the siblings has a number of different judgments. The lender wants to be in first position, and what we have to do is to get his signature. Everybody else has signed. I've signed. My brother in Michigan has signed. My sister in California has signed. We have the brother here that has not yet signed but intends to do so, so that we can clear all of the number of judgments that he has as a 25% shareholder of the property. Now, once that's done, then we're free to go. And let me just say this: what we intended to do, what we are doing, is not only paying her the $10,000, but we're prepared to pay her up until March so that I'm paid ahead. I don't owe her. The child support issue will not be an issue. Also, we're paying Judith Swinney, I believe it's $340 for the 4 different visits for Ezekiel. So I have all the paperwork here from lawyer's title. I also have in the courtroom Richard Gill, who you know was a witness. I had met Mr. Gill many, many years ago when we were doing professional credit restoration, and as a mortgage broker and loan officer, he was the one that helped me to do this. And a lawyer's title, which is a branch of Fidelity, are his people that he's done business with for many, many years. And I have the information here. Mr. Gill, since he's been involved with this title company and the lender, can speak on this much better than I, because he's the one that's put it all together along with the lender. But all the paperwork is here. The money's coming. We just need a little bit more time to close. Then she'll get all of her money. It's all here. It's all facts. We started this.
Much more time, Mr. Gibson?
I believe that we can do this rather quickly, but just so that I'm not in this situation again, say in 2 weeks, we're asking for 30 days. I do believe that we'll be able to close long before that. But I don't want to be in this situation where I'm in front of you again, and you're saying, well, you told me 2 weeks, and 2 weeks has passed, and then, and I see the guys in the back of the courtroom, and I don't want to do that. So I'm asking for 30 more days. You have all the information, the title company people, the lender, their phone numbers are all here. The amount that we're trying to get is all there. We're doing some other things. We're doing some repairs on the property. So we're taking somewhat more than what is owed Miss Martin. This is why it would be very easy to pay her up until, I believe, March is what we're looking at doing, up until March of 2012. And then the child support issue will not be an issue no longer.
The $10,000 figure I gave you was a low estimate, and looking, just quickly perusing the previous judgments that were entered. So I don't want to give you the impression that it's 10 plus what's ever owing for
Might I pass
January,
this to her
February,
and let you
March.
see this, and you'll see there's plenty of money to pay her what she needs.
I don't know the figures, all I'm telling you.
Okay, all right, I understand.
Until she submits the paperwork, I don't know what's exactly owing to you.
Well, we're assuming $10,000 plus January, February, and March. That's what we're assuming, but like you say, until she has an exact figure. And what I'll do is go back and look at my records, as you just suggested, to see if, in fact, her figures and my figures, based on my information, are the same or relatively close.
Okay. Any questions or comments?
Yes, it's not fair to say that I just blew this off. I am raising a child. I've paid for everything for years while he's whined about the economy. I'm responsible for all the legalese. And since he filed another report with DHS, they've had me hopping through hoops. The supervisor wants things for me. I ran up here and spent $22 on a certified copy. And we've had 2 holidays which require the child being in my care 24/7. So I'm expected to keep up. I'm expected to pay no matter how bad the economy is to make sure this child goes forward. And he gets one break after another. And yesterday, he was so out of hand in our meeting with Dr. Hardy. I still don't feel safe. And I don't even care about the money. I want this to end with me and the child being safe. And I don't know what else to do.
Okay, in looking through the other hearings that we had, specifically at one on February 17th, 2011, which was a contempt hearing also for non-payment of child support, the court found Mr. Gibson in contempt for failure to pay his support obligation, and Ms. Martin was ordered to prepare the orders from that hearing from February of 2011. She's failed to do that also. So unless you can get the paperwork up to date so that he can take care of his financial obligations and we can move along in this case, we keep spinning around in circles. So
he's a petitioner. Why am I responsible for everything?
Well, I don't see it that way, but at this point, you are required to prepare the orders for support. In order to hold him in contempt, you have to set forth what's owing.
Fair enough. I would request, if he can't pay his child support today, he has no business spending $360 on a supervisor before that is taken care of.
I'm not dealing with that today.
Right.
I'm not dealing with that
I
today.
just said that.
The matter that was before me a couple weeks ago, and not on a contempt matter, Mr. Gibson volunteered to bring in $10,000 because he knew he was behind. And I gave him the opportunity to bring it in today. He's given me testimony that he's taken the steps to get the money. He needs 30 more days to do it. I will allow him to do that in order to bring his support obligation up to date. Now, in order to stop spinning our wheels here, you need to get the paperwork in so that we can proceed and finalize this.
But if he has $360 to give the supervisor, why can't he give it to me for child support to make my load of paying for this whole family, keeping up with the legalese, and keeping the child going forward? If he's got that money, he should be paying me something today.
Your Honor,
The problem is there's not something before me to order him to do that. There's not a proper motion for contempt filed by you based upon a previous court order telling me to do that. So that, I can't order him to do that today. You have to get the paperwork in order for me to take the next step to order him to pay and be in contempt if he does not. That's what we need to do. Any further questions?
So 30 days from now, we're going to start this over.
Hopefully, we're going to conclude it if you get the paperwork in, and I have a number that I can require Mr. Gibson to pay. I need to order him to pay X amount of dollars pursuant to that support order that was entered back when.
Your Honor, do you need to have this? Okay.
I filed, never mind. So if I get these numbers to you tomorrow, then what happens?
Mr. Gibson will then know what the bottom line is that he's going to need to come up with.
And he gets 30 more days to do that.
He's got 30 days from January 5th, so today, the next
February 5th.
next hearing,
Yeah,
that's
you know,
that's
we
a Sunday, so.
had researched, and even in the best situations with the FHA loans, they're closing with the low interest rates that are everywhere. They're 45 to 90 days in the best situations. Now, this is a situation coming out of my own home, and I thought since, I own the home, I don't owe anything on the home, I should be able to pull the $10,000 out. But then we found that we had all of these different things that my brother had, so it's complicated, and we just need more time.
It is
You
complicated.
gave me the 30-day period. Based upon that, I reset it for today. You're telling me I need more time to get this based upon it's more difficult than I thought it was. I'm allowing you to do so.
Thank you,
And
Your
he
Honor.
gets more time because it's complicated, but I don't.
Follow that.
This paperwork is complicated. I have to pay to get help to fill it out, and I need more time because I've been through a holiday with no money, with a child, with the state on my back because of more charges that he's made, and I don't get any grace or more time, but he does. He shouldn't have access to the child until he pays his child support, and the only way he pays it is when he's threatened with incarceration, but I can't keep up with the paperwork. Sorry, ma'am, you lose.
The Supreme Court of the State of Washington said you can't hold the payment of child support as bondage for visitation. Okay? I can't do that. There's case law to that authority. So I can't deny someone the right to visit because they don't pay child support.
So after acknowledging 8 years of domestic violence, you lifted the restraining order, you didn't order any treatment, he was screaming and yelling in front of his pastor, calling me a witch and demons, and now I'm out there twisting in the wind. My child has to go be in a room with him when nothing has changed or been resolved. Thank you, Your Honor.
You're entitled to your opinion.
Oh, it's my experience, Your
No,
Honor.
Your Honor.
Okay, thank you. We'll see you on February 2nd at 9 o'clock. February 2nd at 9 o'clock.
February 2nd.
Yeah, that's a Thursday.
Is there something that...
I'll write an order to that effect.
Your Honor, title can help.
Ms. Martin, hang on. You need a copy of the order for the reappearance date.
Your Honor, also, title is willing to help her prepare the paperwork for the monies coming to her. She would so like to have that help, as she's saying that she's trying to do this all by herself.
Who?
The title company that's writing her the check.
I don't think they do Washington State child support orders. I know there was an order entered for the temporary child support that Ms. Martin could have almost copied as a guide to help her in preparing this order.
You are a trial lawyer, Your Honor.
Ms. Gibbs, Ms. Martin, that's enough. That's enough, please. So I'm putting that you're to bring not less than $10,000 to court that day as payment on your arrearage. You know, and Mr. Gibson, Ms. Martin does raise a good point. If you have money for other things, you have money to be paying her some child support while we're waiting for this to go through.
Your Honor.
That's my point. Just listen to it, because everything that I hear and listen always affects what I do in the future. So if you have the ability to do other things to pay for your child, you have the ability to send her a check too. Okay?
If
That's said. Have each of the parties sign as notice, acknowledged to reappear on that date.
Thank you, Your Honor. Have a good week.
Thank you. Concludes the matter.